a unique perspective on that, and we appreciate your statement. I'll begin the questions with Dr. Waldron. Dr. Waldron, in the patent world, there are many hurdles that a foreign country can raise to prevent a company from selling a product based on a lawfully granted patent. But in recent years, we've seen countries like Brazil, Thailand, and India using the threat of a compulsory license as a negotiating strategy to force American companies to manufacture or license their products to local companies at government-mandated prices. Recently, India took the unprecedented step of issuing a compulsory license against a Bayer oncology drug, stating, among other reasons, that the patented drug was not being sufficiently worked in India because it was not locally manufactured. What steps can the U.S. government take, or should it have taken, to ensure that countries think twice about using a compulsory license simply as a negotiating strategy or to facilitate their budget planning?
The U.S. government should take a hard line on these issues. I think if you liken compulsory licensing to the lifeboats on an ocean liner, it's like you don't frequently see those being employed except in extraordinary circumstances. In fact, if they're used regularly, one would begin to question the sanity of running ocean liners if that would be the only recourse. What we really need to do is get to the heart of why some of these countries are imposing compulsory licensing. Some of them are for fiscal reasons. They haven't put enough money in the budget for their healthcare systems. These are not extraordinary circumstances that would justify essentially the abrogation of an individual patent holder's rights. I mean, this has a direct effect if it were to continue and extrapolate it to other countries, and other countries may mimic what has happened in Brazil and India and Thailand, would be devastating upon U.S. industry. This has a direct effect on our ability to sell drugs in those countries. It has a direct effect on the investment that we put into developing drugs that may be of use in those countries. And it has a direct effect on the jobs that are created in the United States. We have a competitive advantage versus the rest of the world in the biopharmaceutical and biotech area. We should not hesitate as a government to go forward and protect the interests of our companies, particularly our competitive advantage versus those in the economic area.
And if the Indian government's decision is not reversed on appeal, do you envision an increased risk for other patent-protected drugs or even other patented technologies in other areas like energy, communications, and the Internet basically being taken away by foreign governments? I'll ask you, and then I'll ask Mr. Israel the same question.
I believe there is a risk. This is something that is being experimented with, and I think it's also a test of our resolve to see whether we're going to stand up for these, our own industry in these contexts. If we don't send a hard message on these issues, I think we'll find it increasingly difficult to combat it at a later stage when sort of the horse is out of the barn. I believe it's important to make a statement very early about this because we'll find green technology and other industries under the same pressure, and when we find the whole panoply of our industries under siege and unable to do business in these countries, I think we'll find ourselves in a sorry state.
Thank you. Mr. Israel?
I think the dynamic that you lay out, Mr. Chairman, is exactly correct, and I think we're seeing it play out in real time. I think we have seen in recent years the threat of compulsory licensing being applied or at least discussed in relationship to clean technologies. I think we need to be also very aware that this isn't just an individual nation concern, but it's a more global concern because a lot of the countries that are using this tactic or threatening this tactic are also working very hard within global organizations such as the WTO, the World Intellectual Property Organization, to promote this type of position, to promote this type of a framework. Brazil, for example, has recommended within the Standing Committee on Patents at WIPO that a manual be put together that would instruct countries on how to essentially work around intellectual property rights. So as Dr. Waldron lays out, this is something that has a slippery slope dynamic to it. I think we're seeing it played out in real time, and I think on the compulsory licensing question, we need to be very focused on the prongs that exist within TRIPS that do allow for a compulsory license. You need to exhaust the negotiations with the rights holder, and there needs to be a true emergency at hand. And I think in very few, no circumstances, really have we seen those prongs being met, and it has largely been used as a tool, either as a negotiating tactic or for other competitive purposes.